The tension in the Supreme Court chamber was palpable as Justice Clarence Thomas leaned forward, his expression unusually animated for the typically reserved jurist. The high-profile case challenging a controversial state voting law had already drawn national attention, but no one anticipated the extraordinary direction oral arguments were about to take. "Counsel," Justice Thomas began, his deep voice carrying an edge that immediately silenced the packed courtroom. "Before you continue, I must address what appears to be a fundamental misrepresentation of precedent in your brief." The cameras panned to Congresswoman Jasmine Crockett, who stood calmly at the podium. Her appearance before the Supreme Court as lead counsel in this voting rights case had already made headlines. A sitting member of Congress rarely argues before the court, and Crockett's background as a civil rights attorney before her election added additional significance to her representation. "You've cited Baker versus Carr and Reynolds versus Sims as establishing a constitutional right to what you term equal electoral opportunity," Thomas continued, his tone growing increasingly critical. "But that characterization grossly distorts the actual holdings in those cases and fabricates a constitutional principle that simply doesn't exist." Murmurs spread through the gallery as observers registered the unusual directness of Thomas's attack. While the justice was known for his conservative jurisprudence, he rarely confronted advocates with such pointed accusations of misrepresentation during oral arguments. "What's particularly troubling," Thomas added, removing his glasses for emphasis, "is that someone with your legal training and current position would present such a fundamentally flawed interpretation to this court. Either you've misunderstood these precedents entirely, or you're deliberately mischaracterizing them to advance a political agenda rather than a legal argument." The attack was extraordinary. A Supreme Court justice publicly questioning both the legal competence and ethical approach of an advocate appearing before the court. The gallery fell completely silent as the implications registered. Thomas had essentially accused Crockett of either incompetence or deliberate misrepresentation, a devastating charge against any attorney, but particularly one who was also a sitting member of Congress. Chief Justice Roberts shifted uncomfortably, clearly concerned about the breach of the court's typical decorum, while several other justices exchanged glances at this unprecedented personal attack during formal proceedings. Court observers recognized immediately that Thomas's comments had created an extraordinary moment in Supreme Court history, one that would require an equally extraordinary response. What happened next would stun everyone in the courtroom and soon captivate legal experts nationwide. Rather than responding with defensive justifications or deferential retreat in the face of a Supreme Court justice's criticism, Congresswoman Crockett delivered a legal response so precisely crafted, so deeply rooted in constitutional jurisprudence, and so unexpectedly authoritative that it would not only neutralize Thomas's attack, but fundamentally reshape the national conversation about voting rights and judicial philosophy. If you want to see exactly how Congresswoman Crockett transformed this public attack into one of the most remarkable moments in recent Supreme Court history, make sure to like this video and subscribe to our channel right now. Hit that notification bell so you never miss these extraordinary confrontations where preparation meets provocation and creates unforgettable moments of constitutional clarity. Now, let's dive into how this remarkable exchange unfolded and why Crockett's response left even veteran Supreme Court observers speechless. Clarence Thomas had built his reputation as the court's most committed originalist during his 3 decades on the Supreme Court. Appointed in 1991 following one of the most contentious confirmation battles in history, Thomas had established himself as the anchor of the court's conservative wing through hundreds of opinions advocating strict textual interpretation and original public meaning. His jurisprudence in voting rights cases had consistently emphasized states' authority to regulate elections, narrow interpretations of the Voting Rights Act, and skepticism toward claims of discriminatory impact, absent evidence of discriminatory intent. In recent terms, Thomas had become increasingly vocal during oral arguments, often asking the first and most challenging questions that reflected his originalist philosophy. His willingness to overturn established precedents he viewed as incorrectly decided had made him particularly influential as the court shifted rightward, with several recent majority opinions adopting positions Thomas had long advocated in solo dissents. Thomas approaches constitutional interpretation with remarkable consistency, one former clerk had observed in a profile published in the National Review. He believes the Constitution's meaning was fixed at the time of ratification and that judges should apply that original meaning regardless of evolving social or political preferences. This philosophical commitment to originalism and textual fidelity had clearly informed Thomas's unusually direct attack on Crockett's characterization of voting rights precedents. From his perspective, her interpretation represented exactly the kind of evolutionary constitutional approach that he had spent his judicial career opposing, one that he viewed as substituting political preferences for the Constitution's actual meaning. Across the courtroom stood Jasmine Crockett, whose path to arguing before the Supreme Court reflected a very different constitutional vision. Before winning election to Congress, Crockett had established herself as a civil rights attorney in Texas, where she specialized in voting rights litigation, challenging laws that disproportionately affected minority communities. Her legal approach emphasized the practical impacts of election regulations and their effects on different demographic groups, precisely the kind of results-oriented jurisprudence that Thomas had long criticized. She approaches these cases from the perspective of how voting systems actually function for different communities, a former legal colleague had explained to the Washington Post. When she interprets constitutional provisions or statutes like the Voting Rights Act, she's drawing on direct experience, seeing how abstract principles translate into concrete voting access for communities that have historically faced barriers at the ballot box. This perspective had informed the brief and oral argument that had provoked Thomas's unusually direct attack. Crockett had advanced an interpretation of voting rights precedents that emphasized their functional protection of equal electoral opportunity rather than focusing narrowly on their specific holdings, an approach that reflected her view that constitutional principles must be understood in terms of their practical operation rather than just their abstract formulation. The stakes of this confrontation extended far beyond the personal dynamic between Thomas and Crockett. The case before the court challenged a state law requiring specific forms of government-issued photo identification to vote, imposing strict address matching requirements, and eliminating most forms of early and absentee voting. Civil rights organizations had presented evidence that these provisions disproportionately affected minority, elderly, and low-income voters, evidence the state dismissed as irrelevant without proof of discriminatory intent. The court's decision would potentially reshape voting rights jurisprudence for a generation, determining whether the Voting Rights Act and constitutional equal protection principles required consideration of disparate impacts or merely prohibited explicit discrimination. With several states having enacted similar voting restrictions in recent years, the ruling would affect election administration nationwide and potentially determine whether millions of citizens would face significant new barriers to casting ballots. For Thomas, the case represented an opportunity to further cement his originalist approach to voting rights and potentially limit the scope of the Voting Rights Act's results test that prohibited voting practices with discriminatory impacts regardless of intent. For Crockett, it offered a chance to defend a more functional interpretation that considered how voting restrictions affected different communities in practice, a perspective informed by her direct experience representing affected voters before entering Congress. The packed courtroom reflected these high stakes. Civil rights leaders sat alongside state officials in the public gallery, while members of Congress and Justice Department attorneys filled the reserved sections. Supreme Court reporters leaned forward in anticipation, recognizing that Thomas's unprecedented attack had created a moment of extraordinary tension that would require an equally remarkable response. What none of them yet realized was that Crockett had spent months preparing for this exact moment, not just researching voting rights precedents, but studying Thomas's own jurisprudence and constitutional philosophy in depth. Her response would draw not on emotional appeals or political arguments, but on constitutional principles, textual analysis, and historical evidence specifically calibrated to address Thomas on his own jurisprudential terrain. "Thank you for raising that concern, Justice Thomas," Crockett began, her voice reflecting neither defensiveness nor intimidation, but the measured confidence of an experienced advocate. "I welcome the opportunity to clarify precisely how Baker and Reynolds inform our argument about equal electoral opportunity." This opening tone immediately shifted the dynamic. Rather than retreating from Thomas's attack or responding with political counter-arguments, Crockett had signaled her intention to engage directly with the jurisprudential substance of his criticism, an approach that commanded attention precisely because it departed from expected defensive reactions to such a direct challenge from a justice. The phrase equal electoral opportunity doesn't appear verbatim in either opinion, Crockett acknowledged, but it captures the constitutional principle those cases established through their combined holdings and reasoning. "If I may explain specifically what I mean." She gestured toward the bench with a subtle authority that further recalibrated the exchange. This wasn't a flustered advocate backpedaling from a justice's criticism, but an attorney confidently clarifying her constitutional interpretation. Baker established that equal protection challenges to electoral systems are justiciable, rejecting the political question doctrine in this context precisely because the Constitution protects citizens' rights to equal participation in democratic processes, Crockett explained. Reynolds then applied that principle specifically to voting power, holding that the Equal Protection Clause requires that the weight of a citizen's vote cannot be made to depend on where he lives. Her precision in citing these holdings, without notes or hesitation, immediately established her command of the precedents Thomas had accused her of misrepresenting. Several justices who had appeared uncomfortable during Thomas's attack now leaned forward with evident interest in her substantive response. "Reading these cases together," Crockett continued, "we find the court repeatedly emphasizing that the Constitution protects not just the formal right to cast a ballot, but the meaningful opportunity to participate equally in the electoral process." Chief Justice Warren's majority opinion in Reynolds specifically noted that the right to vote freely for the candidate of one's choice is of the essence of a democratic society, and any restrictions on that right strike at the heart of representative government. She paused briefly, allowing the quotation to register. The court recognized that restrictions that diminish the effectiveness of some citizens' votes while enhancing others create precisely the type of inequality that the 14th Amendment prohibits in electoral contexts. Thomas's expression remained stern, but he had not attempted to interrupt, a tacit acknowledgement that Crockett was directly addressing the jurisprudential substance of his criticism rather than deflecting or resorting to political arguments. "I understand your concern about overextending precedent," Crockett said, now looking directly at Thomas. "That's why our brief takes care to ground our equal electoral opportunity framework, not just in Baker and Reynolds, but in the court's broader voting rights jurisprudence, including Harper v. Virginia Board of Elections, where the court held that a state violates the Equal Protection Clause whenever it makes the affluence of the voter or payment of any fee an electoral standard." This reference to Harper, another Warren Court decision that Thomas had criticized in previous opinions, was strategically brilliant. Rather than avoiding Thomas's jurisprudential concerns, Crockett was acknowledging them while demonstrating that her interpretation was grounded in established precedent, not merely political preference. The constitutional principle flowing from these cases isn't that every electoral regulation is suspect, Crockett clarified, but that regulations imposing burdens that fall disproportionately on identifiable groups of voters raise equal protection concerns requiring careful judicial scrutiny, particularly when those burdens affect groups with historical experiences of electoral discrimination. She turned slightly to address the full court. This understanding isn't a misrepresentation of precedent, but a synthesis of the court's recognition across multiple cases that equal protection in the electoral context requires examining how voting regulations function in practice for different communities of voters, not just their facial neutrality. The courtroom remained completely silent as Crockett continued methodically addressing the substance of Thomas's attack. What had begun as his attempt to publicly challenge her legal interpretation was evolving into a sophisticated constitutional dialogue about the proper reading of the court's voting rights jurisprudence. Moreover, Crockett added, this understanding is consistent with the text and original understanding of the 14th Amendment itself. The amendment was ratified specifically to address state actions that, while facially neutral, effectively denied equal citizenship to identifiable groups. The Reconstruction Congress that drafted the amendment was acutely concerned with ensuring that formal equality under law translated into meaningful equality in practice, particularly in the context of political participation. This appeal to text and original understanding was particularly significant given Thomas's originalist approach to constitutional interpretation. Rather than simply citing Warren Court precedents that Thomas might view skeptically, Crockett had grounded her argument in constitutional text and history, directly engaging with originalism rather than avoiding it. The tension in the courtroom continued to build as observers recognized they were witnessing not just a response to criticism, but a substantive constitutional counter-argument that engaged directly with Thomas's jurisprudential concerns rather than dismissing them. This approach was demonstrating exactly the kind of legal sophistication and constitutional understanding that Thomas had implicitly questioned in his initial attack. "Counselor," Justice Thomas interjected, his tone still skeptical but lacking the edge of his initial attack. "Even accepting your characterization of these precedents, they address malapportionment of districts, not voter identification requirements or early voting procedures. The leap from one person, one vote to a generalized, equal electoral opportunity that would invalidate routine election regulations goes well beyond what those cases actually held." It was precisely the jurisprudential challenge Crockett had anticipated and prepared for extensively. "Justice Thomas, that's a crucial distinction that our brief addresses directly," she responded without hesitation. While Baker and Reynolds specifically concerned apportionment, their constitutional reasoning didn't limit equal protection principles to that context alone. The court has subsequently applied those principles to various electoral regulations beyond districting. She turned to another line of cases. In Crawford versus Marion County Election Board, where this court considered voter ID requirements, every justice, regardless of how they ultimately voted, applied some form of a balancing test, weighing the state's regulatory interests against the burdens imposed on voters. The constitutional question wasn't whether states could require identification, but whether particular requirements imposed burdens that outweighed legitimate state interests. This reference to a case where the court had upheld voter ID requirements was strategically brilliant. Rather than avoiding precedent that might seem unfavorable, Crockett had incorporated it into her argument, demonstrating that even when upholding voter ID laws, the court had recognized that equal protection principles required examining their practical impacts on voters. Similarly, Crockett continued, in Burdick versus Takushi, the court established that the level of scrutiny applied to voting regulations depends on the extent of the burden they impose. specifically recognizing that the right to vote includes not just casting a ballot, but having an equal opportunity to participate meaningfully in the electoral process. She looked directly at Thomas again. Our argument isn't that the Constitution prohibits all voter identification requirements or regulations on early voting. It's that when such regulations impose demonstrably disparate burdens on identifiable groups of voters, particularly groups with historical experiences of electoral discrimination, the Equal Protection Clause and the Voting Rights Act require courts to carefully scrutinize whether those burdens are justified by legitimate state interests. The precision of this constitutional framing continued to command attention throughout the courtroom. Rather than presenting a simplistic political argument about voting access, Crockett had articulated a sophisticated legal theory grounded in the court's own precedents and constitutional principles. Justice Thomas, she continued, I understand your concern about extending precedent beyond its proper scope. That concern reflects the judicial restraint that you've consistently advocated throughout your tenure on this court. But respectfully, our argument doesn't require creating new constitutional rights or even extending existing precedent. It simply requires applying the constitutional principles this court has already established in the voting rights context to the specific facts presented in this case. This acknowledgement of Thomas's judicial philosophy, particularly his emphasis on restraint, represented another strategic element of Crockett's response. Rather than dismissing his jurisprudential concerns, she had incorporated them into her argument, demonstrating that her position could be reconciled with conservative constitutional principles. The record in this case contains extensive empirical evidence that the challenged provisions impose substantially greater burdens on minority, elderly, and low-income voters, with some communities facing effective reductions in voting access of up to 45% compared to other demographic groups. This disparate impact isn't speculative or theoretical, but documented through statistical analysis and direct testimony. Crockett turned to address the full court again. The constitutional question isn't whether states can regulate elections. They clearly can and should. It's whether regulations that produce such dramatically unequal burdens on different communities of voters are consistent with the equal protection principles this court has recognized in its voting rights jurisprudence. Principles that protect not just the formal right to cast a ballot, but the meaningful opportunity to participate equally in the democratic process. As she concluded this portion of her argument, the courtroom remained completely silent. What had begun as Thomas's attempt to publicly challenge her legal interpretation had been transformed through her response into a sophisticated constitutional dialogue about the proper application of equal protection principles to voting regulations, a dialogue in which Crockett had demonstrated precisely the kind of legal understanding and constitutional sophistication that Thomas had initially questioned. Even the justice himself appeared to register the substantive quality of her response. Though his expression remained inscrutable, he had shifted from dismissive criticism to engaged listening, the clearest indication that Crockett's argument had commanded his intellectual attention, if not his agreement. Chief Justice Roberts, clearly recognizing the significance of this exchange, intervened. Thank you, Ms. Crockett. Let's turn now to the specific provisions challenged in this case. Justice Kagan, do you have a question? As questioning continued, legal reporters could be seen frantically taking notes, recognizing they had just witnessed one of the most remarkable exchanges in recent Supreme Court history, a moment when a justice's unprecedented personal attack had been met not with defensive retreat or political counterattack, but with a substantive constitutional response that had potentially reshaped the entire framework for analyzing the case. The impact of Congresswoman Crockett's extraordinary response to Justice Thomas's attack was immediate and far-reaching. As oral arguments concluded, legal experts who had witnessed the exchange emerged from the Supreme Court building to find news crews waiting for their analysis of what many were already describing as a historic moment in the court's modern history. What we witnessed wasn't just an advocate effectively responding to criticism, but a fundamental shift in how this case will be understood, noted constitutional scholar Lawrence Tribe. Representative Crockett didn't merely defend her interpretation of precedent, she presented a comprehensive constitutional theory of equal electoral opportunity grounded in text, history, and the court's own jurisprudence. That framework will be impossible for the justices to ignore as they deliberate this case. Supreme Court reporters filed stories highlighting the unprecedented nature of both Thomas's direct attack and Crockett's substantive response. Headlines like Thomas-Crockett exchange reframes voting rights debate and unprecedented Supreme Court confrontation could reshape election law captured the extraordinary significance of the moment for readers who hadn't witnessed it directly. Legal blogs and constitutional commentary sites filled with detailed analyses of the exchange, with particular focus on how Crockett had engaged directly with Thomas's originalist jurisprudence rather than simply citing Warren Court precedents he might view skeptically. This approach, meeting Thomas on his own constitutional terrain rather than dismissing his concerns, had dramatically altered the dynamics not just of the oral argument, but potentially of the court's internal deliberations. By grounding her equal electoral opportunity framework in constitutional text, original understanding, and the court's established precedents, Crockett presented a theory of voting rights that even originalist justices must seriously engage with, explained election law expert Richard Hazen. She didn't ask the court to create new rights, but to apply existing constitutional principles to documented disparities in electoral access, a framing that bridges traditional ideological divides in voting rights jurisprudence. For Crockett herself, the aftermath brought both increased prominence and enhanced credibility as a constitutional advocate. Legal organizations across the ideological spectrum invited her to speak about constitutional interpretation and voting rights, recognizing that her response to Thomas had demonstrated a sophisticated understanding of multiple jurisprudential approaches rather than a narrowly partisan perspective. What distinguished the Congresswoman's argument, noted conservative legal scholar Jonathan Adler, was her engagement with originalist concerns rather than dismissing them. By connecting equal electoral opportunity to the 14th Amendment's original purpose of ensuring substantive equality in citizenship, she presented a theory that deserves serious consideration regardless of one's interpretive methodology. Law schools incorporated audio of the exchange into constitutional law courses, with professors using it to demonstrate how effective advocacy requires understanding and engaging with multiple interpretive approaches rather than appealing exclusively to precedents or principles that align with a particular judicial philosophy. The exchange exemplifies what we try to teach our students about constitutional advocacy, explained Yale Law Dean Heather Gerken. Rather than treating different interpretive methodologies as entirely separate languages, Representative Crockett showed how principles of equal citizenship and meaningful participation can be articulated through multiple constitutional frameworks, making her argument accessible to justices with diverse jurisprudential approaches. Perhaps most significantly, the exchange influenced subsequent media coverage of voting rights issues beyond the specific case. Legal journalists increasingly distinguished between simplistic political debates about voting access and more substantive constitutional questions about how electoral regulations affected different communities of voters, a distinction that Crockett's response to Thomas had highlighted with remarkable clarity. The Thomas-Crockett exchange demonstrated why voting rights debates require attention to both constitutional principles and empirical realities, observed New York Times Supreme Court correspondent Adam Liptak. When discussions move beyond partisan talking points to engage with how electoral systems actually function for different communities, we gain a more comprehensive understanding of what equal protection means in democratic contexts. When the court issued its decision 3 months later, the impact of the exchange became even more apparent. Though the court upheld some provisions of the challenged law, it struck down others using a framework that explicitly considered their disparate impacts on different voter communities, an approach that legal analysts immediately connected to Crockett's equal electoral opportunity theory. Most remarkably, Justice Thomas himself wrote a separate concurrence, acknowledging that while he remained skeptical of results-based approaches to equal protection, the original understanding of the 14th Amendment included ensuring that facially neutral state actions did not effectively deny equal citizenship rights to identifiable groups, particularly in the context of political participation. The concurrence represents an extraordinary moment in Thomas's jurisprudence, noted Supreme Court historian Linda Greenhouse. Without abandoning his originalist methodology, he incorporated elements of the functional approach to equal protection that Crockett articulated during oral argument, demonstrating how her engagement with originalism rather than dismissal of it created space for jurisprudential evolution. For voting rights advocates and election officials nationwide, the court's decision, clearly influenced by the Thomas-Crockett exchange, provided a more coherent framework for evaluating electoral regulations than had previously existed. Rather than treating every voting requirement as either categorically permissible or impermissible, the ruling established that courts must consider both legitimate state interests in election integrity and documented disparities in how regulations affected different communities of voters. The court's approach reflects precisely the balanced constitutional theory that Representative Crockett articulated in response to Justice Thomas's criticism, explained election law professor Daniel Tokaji. It recognizes states' authority to regulate elections while ensuring that regulations don't effectively create two-tiered systems of electoral access based on race, age, income, or other characteristics. As for the exchange itself, it had become required listening for constitutional law students, a model for advocates appearing before the court, and a powerful reminder that even the most challenging moments in oral argument can become opportunities for constitutional enlightenment when met with the right combination of preparation, perspective, and principled engagement with diverse jurisprudential approaches. In transforming Thomas's unprecedented attack into an opportunity for sophisticated constitutional dialogue, Crockett had not only advanced her client's case, but potentially reshaped voting rights jurisprudence for a generation, demonstrating the remarkable power of substantive legal argument to transcend political divisions and create space for constitutional evolution, even in our most polarized political contexts. If you found this breakdown of the Thomas-Crockett exchange informative, please hit that like button and subscribe to our channel for more in-depth analysis of consequential Supreme Court arguments. Click the notification bell to make sure you never miss our coverage of the cases that reshape constitutional understanding and democratic participation in America. Your support helps us continue bringing you detailed analysis of how our legal system evolves through the interaction of prepared advocates and engaged justices across the ideological spectrum.